I'm Ben Meiselas with Karen Friedman Agnifilo from Legal AF, and we have a breaking news alert. The D.C. Circuit Court of Appeals has affirmed most of the federal judge Tanya Chutkan's gag order imposed on Donald Trump in the D.C. federal criminal case against Donald Trump for his attempt to overthrow the results of the 2020 election. Here is what the D.C. Circuit Court of Appeals ruled. Specifically, the gag order in the district court is affirmed to the extent it prohibits all parties and their counsel from making or directing others to make public statements about known or reasonably foreseeable witnesses concerning their potential participation in the investigation or in this criminal proceeding. The order is also affirmed to the extent it prohibits all parties and their counsel from making or directing others to make public statements about, one, counsel in this case other than the special counsel, two, members of the court staff and counsel staff, or three, the family members of any counsel or staff member, if those statements are made with the intent to materially interfere with or to cause others to materially interfere with counsel's or staff's work in this criminal case, or with the knowledge that such interference is highly likely to result. We vacate the order to the extent it covers speech beyond those specified categories. This was a 68-page order and some really powerful stuff in here, Karen. For example, the Court of Appeals found the record before the district court and its factual findings demonstrate that some of Mr. Trump's speech poses a significant and imminent threat to the fair and orderly adjudication of the criminal proceeding against him. They go through and cite Donald Trump saying, if you go after me, I'm coming after you. His threats to former Vice President Pence, his threats against Georgia Lieutenant Governor Jeff Duncan, his threats against Mark Meadows. And then it goes on to say the record shows that former President Trump's words have real-world consequences. Many of those on the receiving end of his attacks pertaining to the 2020 election have been subjected to a torrent of threats and intimidation from his supporters. Goes on to say Mr. Trump himself recognizes the power of his words and their effect on his audience, agreeing that his supporters, quote, listen to him like no one else. And then the court concluded, we do not allow such an order lightly. Mr. Trump is a former president and current candidate for the presidency, and there is a strong public interest in what he has to say. But Mr. Trump is also an indicted criminal defendant, and he must stand trial in a courtroom under the same procedures that govern all other criminal defendants. That is what the rule of law means. Powerful words. Karen Friedman Agnifilo, what did you make of this ruling by the D.C. Circuit Court of Appeals? All three judges signing on to this.
A couple of things. First of all, in the bizarro world that Trump tries to gaslight us into thinking we all live in by saying things like, oh, free speech, I can do this, and saying that I'm not responsible for what other people do, et cetera. It's wonderful to see the court finally just acknowledging, and this is an appellate level court, so this will apply. This is going to be the law for now of the case. Hopefully the Supreme Court doesn't get involved in this. But this is a very, very great affirmation, I think, not just on the rule of law, but also just the ability to protect the court system, right? One of the things they talk about is how important it is for a judge to be able to protect the integrity and the fundamental right of her courtroom. And they are very meticulous going through just what it is that Donald Trump has done, when he does it, how quickly, like the minute something happens, he does it right away, and then something happens as a result. And it just, there's a direct cause and effect that could have a negative impact on the trial, and how important it is to protect the sanctity of the court process and of the trial, and reminding everybody that he's a criminal defendant. And so as a result, he doesn't have his rights can be limited. And another couple of things that I thought here is, because of this ruling, I think you're going to see a lot more judges in the courts who will feel more comfortable actually doing a limited gag order for the same reasons, right? In order to protect the integrity of their courtroom. I could see Judge Merchan, for example, becoming more comfortable with this concept. Obviously, Judge Angoran, this is ongoing in that courtroom and in the appellate courts in New York. It again, this just affirms this concept generally. And I think other judges are going to watch this and rule accordingly and take their lead from the DC Circuit, which, every single district court is overseen by a circuit court, right? And we have the First Circuit, the Ninth Circuit, and all the numbered circuits. But then we also have the DC Circuit that sits over the Washington DC, and not that they aren't all extremely prestigious, but the DC Circuit is often looked at as one of the most prestigious because it's a feeder, or so it used to be, to the United States Supreme Court, and many of the United States Supreme Court justices came from there. So it's and they oversee obviously our nation's capital and issues that happen there, and so the fact that this is coming from the DC Circuit and not from circuits that are considered either liberal or conservative, et cetera, I think also will mean a lot for others. One other thing that I noticed that was in here was that I think is going to be telling in the Chutkan case, because the other thing that's happening right now is Trump is doing a motion for a stay of the entire trial because of the presidential immunity issue that he's appealing. And many people are wondering, oh no, is this going to delay the trial because he's going up to the DC Circuit? And one of the things they said in here was, because the trial is imminently happening, we put this on an expedited schedule and got this out, because if you remember, oral arguments were a week ago, and they already got this decision out. So I think this will also, that's telling how they're viewing this. And I do think that if Jack Smith, for example, in that stay motion asks for an expedited briefing and decision, we'll at least get that before in time, so that hopefully the trial doesn't get delayed and will still go forward in March. So this is a great affirmation, I think, in terms of all of the things and considerations that a judge should and can take into consideration. And I think it's great. One of the things he called out was, you can't mess with the family members, right? Because that's just wrong. You can't mess with, you can say what you want about the special counsel, but you can't rope in family members. It's just not right. And of course, they also did court staff, because they themselves have court staff and they know what that's like. But so it was just, I thought it was a very well-balanced ruling that balanced the rights of the First Amendment rights of someone running for president, as well as having a fair trial.
And the DC Circuit Court of Appeals went back, looked at its precedent, and tested its precedent against the arguments that Trump and Trump's lawyers were making before it, where Trump argued this clear and present danger test required, in essence, that a witness be physically harmed before the gag order can apply. What the DC Circuit Court of Appeals discussed in the order is that while the Supreme Court's clear and present danger language reflects the Constitution's great solicitude for free speech, the Supreme Court has said explicitly that the clear and present danger is not the proper formula for adjudicating these types of cases. Instead, the Supreme Court has instructed that what clear and present danger translates to in practice is that courts must analyze whether there's any compelling interest that justifies an appropriately limited speech restrictions, yet Trump has refused to argue for any such weighing, insisting on just clear and present danger, basically meaning that the actual threat is executed upon. The DC Circuit Court of Appeals also goes through the precedent of a case called Gentile, which is one of the main topics about one of the main cases on the topics about when there could be restrictions on speeches in a criminal case, as opposed to outside of the solicitude of when a criminal case is taking place. And in Gentile, the Supreme Court held that the First Amendment allows the court to prohibit the speech of a trial participant when the speech poses, quote, a substantial likelihood of material prejudice to an adjudicative proceeding. So applying that precedent to the facts here, and finding, as it did, that, look, we do not take this order lightly here, but that Donald Trump's conduct and the factual record does demonstrate that some of his speech poses a significant and imminent threat to the fair and orderly adjudication of the criminal proceeding against him. And that's very powerful words for a court of appeals to be using here. And to the point that you made too, they didn't affirm all of the gag order, but the pertinent parts of the gag order have been affirmed, protecting the witnesses, court staff, staff of the special counsel, family members of any counsel, and staff members if the statements are made with the intent to materially interfere with or to cause others to materially interfere with counsel or staff's work in this criminal case. So a big ruling out of the DC Circuit, and as you mentioned, Karen, with even potential broader implications as Donald Trump is now appealing the district court judge Tanya Chutkan's denial of his motion to dismiss the indictment on presidential immunity grounds, and an indication, at least by this panel, that they want to move this case along. So stay tuned, folks. Always appreciate doing these duets with you, Karen, and we'll be back with more here on Legal AF. Make sure you hit subscribe. We're on our way to 2 million subscribers thanks to your support, and have a great day.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.